Good morning to those in the room and also to those of you online. Welcome. My name is Godfrey Cromwell. I'm an independent member of the House of Lords, and I have been supporting the progress of the anti-SLAPPs issue and trying to get it into legislation. As David Davis said, we have a very long way to go. And it's good to have you all here as part of that. The opening speakers excellently set the context of all this, so I'm not going to repeat what they say, merely thank them for saying it. It's really important what they had to contribute. Now, this session asks whether the UK's anti-SLAPP reforms are a big enough step in the right direction. I hope you've got the programme in front of you, setting out who the four speakers are. But in short, going left to right, we have Susan Cocktree, who is Deputy Director of FPC, crucially is the author of the London Calling report, which was a real milestone in taking this forward. We've got Tom Burgess, who has emerged victorious from 2 SLAPP cases after writing Kleptopia. We have Rupert Coper-Powles, who's a partner in the law firm RPC, and on the end, Jill Phillips, who's the director of the editorial legal services at The Guardian. So I'm going to let them speak for about 5 minutes each. That means there's lots of time for questions. So I look forward to your questions. If you're in the room, please catch my eye by any means that you wish to use. If you're online, we will be picking up questions from the toy in front of me. Please put your questions in the Q&A function if you're online. If you wish to indicate who you are, please do so. Please don't give a 20-minute introduction to the marvellous things your NGO is doing. We like questions, we give points for brevity, and we don't like speeches. That's what this lot are for. Okay, so let's kick off. Susan, away you go.
Thank you very much. Well, I think this is a very exciting moment for us because we held this conference, the first edition of this conference, a year ago, and it feels in some ways like it's shot past, and in other ways it feels quite remarkable to take track of all the progress that we've achieved in this year. And of course, all 3 of my fellow panelists were also speaking last year. And at that time, Tom, of course, still had his case ongoing.
I rang in from court.
You did. You rang in from court. So it is a really nice moment to realise how far we've come. I mean, the UK Anti-SLAPP Coalition started in January 2021. And in that sort of first year, last year, in the lead up to the initial conference we held, we were really kind of working together to highlight cases like Tom's, like Catherine Belton's, Carol Cadwallader and others. But we were always looking at what could be the solution. And at the last year's conference, we presented some draft proposals for reform, which provided, some sort of pathways, I would say, into what we have managed to do this year, namely draw together a model anti-SLAPP law, which has already been mentioned was launched last week even, in Parliament. So I feel, in answer to the main question of this panel, is that we have come a long way. We are looking at solutions in the form of the legislative solutions, and unfortunately, as David Davis alluded to, we do have commitment, but we don't have a timeline. So there's still quite a lot of work to be done on that front in terms of pushing those legislative proposals forward. But we have a great model for the government to lean on, with a lot of support from many quarters, not just the NGO quarters, but the media and from the many kind of legal supporters. But we also have some regulatory solutions. So one of the recommendations we made last year, and was also in the London Calling report that FPC published earlier this year with Article 19, was for a anti-SLAPP warning notice, which is a tool. The Solicitor's Regulatory Authority produce warning notices. They produced one previously on non-disclosure agreements a few years ago in light of the Me Too movement, when it was clear that NDAs were being misused to suppress information about sexual harassment and abuse. And this has now moved forward that the SRA have announced that they will be imminently releasing a warning notice on SLAPPs, which will provide some very concrete guidelines as to how lawyers can engage. Because as we know, it's not just the cases that reach court like Tom's, but also this whole area beforehand, which is the unseen bit of the iceberg we keep referring to. So I'm sure there's going to be questions about various different aspects of things that have happened. But I think as a summary, we're pleased to have seen so much of the work that we've done taken forward, but we're not there yet.
Thank you very much, Susan. Go on, clap. Go on, clap. That'll do. Thank you very much. Yes, much still to do, round one, as our earlier speaker said. But yes, certainly a heck of a lot to do, and I may have a question on that later. But over to you now, Tom.
Thank you. I think if we're tempted at all to congratulate ourselves and think that the job is done, we should remember what we're really talking about here, which is a part of a war. It's been going on for a long time, far longer than the hot war in Ukraine. This is an undeclared, asymmetrical war between kleptocracy, ruled through corruption, and democracy. It's as simple as that. And the way that kleptocrats around the world have used the British legal system to silence the free press, the British free press, and and courageous journalists all over the world, is part of that war, and it's part of the reason we're losing that war. In early 2020, when we were reading the first news reports about a troubling virus emerging from China, and the first Asian countries were starting to lock down, I made one last reporting trip for a book I was working on called Kleptopia: How Dirty Money is Conquering the World. And I went down to South Africa, where I used to be a correspondent years before. And what I found there was very dark and troubling. I was shown some autopsy photos of a burned body in the back of a car just outside Johannesburg. And the corpse was that of a guy called Andre Becker. We still don't know what happened to Andre, whether he was killed, although it seems almost certain that he wasn't, who did it. But we do know that one of the things he was aware of before he died was a dodgy mining deal. And I also heard while I was down there about the deaths of two other South Africans on the other side of the world in the US. They'd been on a biking trip and they'd been found dead in adjacent hotel rooms in 2015. And the cause of death was given as malaria. But the reporting I was doing by then showed that that was impossible. What these three men had in common was that they were all potential witnesses in a criminal case being run by the Serious Fraud Office in the UK. That is, I think, one of the defining cases in this struggle between kleptocracy and democracy. It's the investigation into a huge multinational mining company called ENRC. And in my book, which came out a little later that year, published by HarperCollins, and in an FT, Financial Times magazine story, I was working for the Financial Times at the time, I wrote about this. I wrote that we didn't know what had happened to these men, but we knew their deaths were suspicious, and therefore we knew that the deaths of potential witnesses in a major UK criminal investigation were suspicious. Now, before published Kleptopia, in that lockdown summer, we sent out, and there were people in this room who bear the scars of this, and we sent out letters to everybody who's going to be named in this book, and we got back legal correspondence that ran to 600 pages, twice the length of the actual book. And after it came out in September 2020, almost all of that went quiet. But the lawyers for ENRC, that's the lawyers at Taylor Wessing, they kept going, and actually more lawyers got involved. ENRC is a enormous mining company. It used to be listed on the London Stock Exchange. It used to be in the FTSE 100, so one of the most valuable British registered corporations. It was founded by three oligarchs from the former Soviet Union who go back to the KGB days of turning communist power into capitalist money in the 90s, and then spread their influence all over the world and picked up a lot of African mines. And the Serious Fraud Office is investigating allegations that the acquisition of those mines was done through corruption. So this is a huge web of a company that connects kleptocratic power all around the world. And and their lawyers, Taylor Wessing, sent some threatening letters. And then we had American lawyers, Boy Schiller, sending letters in the States trying to force the publisher of the US edition to reveal anything they knew about my sources. Then we had an open court filing accusing me of being corrupt. And that court filing's still there and will always be there. Completely baseless, but nonetheless part of the public record. And then just before Christmas 2020, I was shown a letter that wasn't to me, but was from another American law firm, Quinn Emanuel, from their London office, sent to someone I'd met along the way, someone who used to work on this investigation. And that letter accused him of all sorts of ridiculous things, one of which was the heinous crime of talking to a journalist. And they knew he'd done this because they watched him meet me in a car park. And they made that very clear that they'd been watching by telling him the colour of the notebook he'd been carrying at the time. Anyway, by the time the book had been out for a year, we'd nearly got to the point where a libel action is time barred. You get a year to bring a libel case. We almost got to that point, but then Taylor Wessing, the London lawyers, they came through and they issued a writ. They sued me personally, they sued the Financial Times, and they sued HarperCollins. And it took about 9 months to get us to the point where me and Arabella Pike, my magnificent publisher, and a couple of others who worked on this case in this room, were in a pub celebrating a spectacular victory. But the strangest thing about it was that on day one, leaving aside all the fear and anxiety, the personal worries about my family and the deeper worries about protecting my sources, for all of that, any independent observer could have said on day one, this case is absolute bollocks. It was ludicrous. The central allegation was that I had written that a holding company, essentially a piece of paper, had murdered some people. I mean, my 6-year-old knows that that's rubbish. And yet, HarperCollins is still down significant amounts of money, even though we got awarded all our costs. Amounts of money that's equivalent to books, valuable books that could have been published. And the company continues to operate around the world, more or less unchallenged. We don't know where the criminal case will end up. The company and its lawyers continue to maintain that they've done nothing wrong. And we still don't know the cause of death of those 3 men. But what we do know, because of the Brexit work that Susan and others have done, is that cases like this are very rare, where we're lucky enough, journalists and writers are lucky enough to have spectacular foursquare support of well-resourced media organisations. And the real damage that's being done here is all the stories we're not talking about because we don't even know about. The ones of great public interest that are being spiked every day because the journalists are too scared to do them, their editors are too scared to run them, and because London law firms whose senior partners wield power equivalent to that of a Fleet Street editor in deciding what we get to read and what we don't get to read, are making just those decisions every day on behalf of clients whose interests are completely inimical to democracy.
Thank you, Tom. And I think you've illustrated beautifully both the complexity and the agony of this whole experience that anybody who suffers through a SLAPP process experiences. So thank you for that. I'm going to move on to Rupert now. Rupert, where are you at?
Well, I hope to give, in just a few minutes, a perspective on the government reforms as a private practice solicitor. So I work at one of a handful of London law firms that defend the media, that never act against the media. I'd say for every one of me, there's probably 8 or 9 claimant solicitors or lawyers. This is big business, the reputation management business. And
the house is a bit bigger than yours as well, aren't they, Rupert?
Yes, unfortunately. And it's in terms of the government reforms, this has been desperately needed. I mean, it's the last couple of years since one of my clients, Claire Rucastle Brown, put me in touch with Susan and the various organizations have been pushing on this campaign. It was a sort of wake-up moment where this depressive situation where brave organizations, media organizations, NGOs, and journalists are having to decide between the principle of fighting to get a story out or facing the commercial reality that they might be jeopardizing their entire legal budget, the employment of staff, or, in the case of freelancers, their house or their retirement on a story. I mean, that's the reality of what we're often having to advise our clients when they're facing SLAPP cases. And in terms of the government reforms, I'd give them. I'm very glad that they've recognised there's a problem. During the consultation process, for the most part, there was almost no recognition that there is any issue from private practice solicitors and counsel on the other side of the divide. And it was during the consultation process, it was quite remarkable how stark the division is, the perspective is between those who are facing these claims and those who are on the other side saying we're entitled to write these letters, entitled to bring these claims. A statutory dismissal mechanism is desperately needed. I've looked at in several cases which were regarded as SLAPPs, trying to strike out cases using common law abusive process, and it's desperately expensive and highly risky. And frankly, to try and develop the kind of case law that Article 10 rights and free speech needs through case law would, if it was ever possible, it would be vastly expensive and risky and take decades. So a big tick for the proposing a statutory dismissal mechanism. The government's also said they want to deal with costs. That's absolutely crucial. The sort of armament of the claimant lawyer these days isn't just libel. It's copyright. It's data protection. It's a misuse of private information. And litigation's just become so much more expensive. 10 years ago, we'd be putting in cost budgets, our estimates for how long it takes to take one of these claims to trial, and it would already be incredibly expensive. It might be £200,000, £300,000 to take this to trial. I don't see cost budgets going in for less than £1 million these days. E-disclosure, where journalists and supposedly the other side need to have all their emails, WhatsApp, documents all uploaded and reviewed. It's an incredibly expensive process. Interlocutory applications are very expensive. So that it's good they're getting to grips with that. In terms of what needs to be done, without diving too much into the detail, it's essential that we're not left with some threshold test which leaves the bar at effectively where we are at the moment on summary judgment or strikeout, like no realistic prospect of success. We need to raise the bar to give free speech more space, more room in our society for public debate, and that needs some sort of that needs an evaluative exercise by the judiciary, looking at the importance of the free speech and looking at the hallmarks of the litigation, looking at these things in the round, rather than a narrow view on the claimant's pleaded case, which is being carefully constructed. I think this legislation is needed more than ever. I'd love it if in 2 or 3 years' time, when we're advising clients on these situations or looking at pre-publication copy for organizations or the media when they're wanting to put this out, that we can say, this smells bad, this looks abusive, you can publish. So we need this desperately, and we're heading in the right direction. There's some wrinkles to work out, though.
Thank you very much. I'm not quite sure whether you're an optimist or a pessimist, but I think on the tail end we came down with optimism, I hope. So thank you very much for that legal take. Now we come to our final panelist. Just to remind you, I've got questions coming in on the toy here, but if anybody wants to catch my attention in the room, don't be shy, please. Jill, can I give the floor to you?
Yes, thanks very much. I mean, I was just sort of thinking about this in the round, where we've come to, what's still to be done, but also looking at it from the perspective of an in-house lawyer, and it sort of seems to me there's all been well planned by the UK anti-SLAPP coalition, but there's sort of been publicity and awareness, and I think that's been really successful. Political engagement is key in these processes, and we've seen a lot of that. But as David Davis said, that the anti-SLAPP law is now in the hands of the government, and that is something that we mustn't forget, and we must keep pushing and putting the pressure on, because, as we know, government and ministers come and go quite quickly. The sort of second tier of that attack, as it were, in terms of trying to get SLAPPs sorted out, is costs reform, which we've already heard people talking about. And again, that is mentioned in the government's response, but it is literally mentioned. There is no detail about that. So there is still a lot that needs to be done to push on the costs side of things. What is going to happen as part of that, and how is it going to happen? Is that going to be legislative? Is that going to be dealt with through the civil procedure rules? So where is that going to fit in? And of course, one of the things about the costs is that they really tend to only kick in once you've been sued. There's a whole, again, the tip of the iceberg's not just the claims that you see, but what goes on behind the scenes in terms of the resources that are deployed in fighting these cases. I've already mentioned the Rules Committee in terms of costs, but it seems to me that there's also a lot there, and we've heard silence from that side of things. As Rupert says, where are the bars going to be put? Are the summary judgment rules, the abuse rules, going to be changed? I mean, and I think that's something that we as practitioners can also do. We need to take up the cudgel now we've got language around these things and try and use some of these mechanisms that we've really not used for very good reason, because we thought we'd never get anywhere with them. But there is now some momentum. I think Matthew Nicklin in Tom's ENRC case, and also in the recent Dyson judgment, you get a sense that they're seeing a slightly bigger picture here. And I think that we as practitioners have to be willing to now start pushing from our end and raising these issues. Interesting in Carol Cadwallader's case, and I'm sure she'll talk about it, but SLAPP wasn't per se part of her defence. It wasn't part of her case. It came up, and the judge dismissed it in rather cavalier terms, some people would say. So I think that there's stuff to be done still there. And then I think, from my perspective, really the key element of it. There's one other thing before I get to my bit, which is resources and training. One of the things that the anti-SLAPP group are trying to do, both here and in Europe, in the wider thing, is set up resources, training, awareness, and that means judges, that means lawyers, that means journalists. It means giving journalists the resources before they publish things to have access to lawyers who can do their pre-pub work and help them to get to the right place in that sort of thing. So, but for me, I think the most important thing that is going to hopefully have the most impact on what we do is the guidance issued by the SRA, because that, as we've heard, the claims that you hear about are the tip of the iceberg. Underneath that, there is a vast array every day of threatening letters being sent by lawyers to journalists. And again, someone like The Guardian, who's got an in-house legal team, we see these letters, we can sort of see behind them and through them. And what we look for is there some fact in here? Are they giving us some information that makes us go, oh, we shouldn't publish this story, we need to go back and look at things? Otherwise, 5 pages of quotes from various cases is not going to work with us. It seems to me you either say our client is not going to comment, end of, or here are our client's comments on the facts, and this is why they disagree. And actually, you rarely get either of those. What you get is 5 pages, presumably for the client to look at and go, oh yes, I'm very impressed by this, and a bill of 10 grand or something. So I sort of think that the anti-SLAPP guidance issued by the SRA, which is saying to claimant lawyers in particular, you've got to think about what you're writing now. You've got to think about the use of these terms that accompany a lot of these letters, saying not for publication. Not for publication in response to a letter from a journalist asking for information with a view to publication is just ridiculous. And it's a unilateral label that is imposed. Likewise, you often get that together with something that says private and confidential. Most of the time, the information in these letters is neither private nor confidential. Occasionally, there might be some information given that is confidential, and that can be identified and sorted out. So, but these are labels that are used to try to put journalists off, to confuse them, to slow the process down. And these are the areas that the SRA is starting to look at. And as Susan said, hopefully there's going to be a warning notice. And as I understand it, I should know this as a solicitor, but in a sort of graduation of regulatory things for us to consider, there's the principles that sit at the top, which are quite vague, quite hard to get to. Then there's a code of practice underneath that. Then there's guidance, which doesn't have any particular effect. And then there are these warning notices that don't often get issued, but can be used by the SRA when they're prosecuting their cases. But again, I think that us lawyers now have to use this and start making complaints to the SRA. And I think the SRA has sort of, either because there have been some individual complaints, but also proactively on the back of names that were mentioned in the parliamentary debates, have taken up some of these law firms and are looking into them and how they're conducting themselves. But as I was just saying to Ros, who's going to speak in a minute about Scotland and Northern Ireland, the Scottish Law Society is silent on this. And actually, it's quite interesting. I was reading the timeline in here. Of course, Oliver Bullock, his threatening letter came from Scottish lawyers. And the Guardian's recent coverage over the last week of Michelle Mone, she's also represented by Scottish lawyers who are writing letters that, you would think that regulators might be quite interested in. So, I think there's still a lot to be done, not just the UK, England and Wales, but these other regulatory authorities and presumably the Bar Council in terms of the litigation side of it. So, I think, from my perspective as an in-house lawyer, that's where I'm looking, both for me proactively, but also to see whether there is some change in the approach that these lawyers are adopting going forward.
Thank you, Jill. And that actually leads very neatly into one of the questions that's come in online, and also something I'm interested in. Thank you, Ewan Grant, for your question that's come in online. What has been the impact on the law firms who are making a lot of money out of this? Are you... Oh, there goes my brain. Are you seeing any improvement in behaviour, or are they closing ranks and getting ready to fight back?
Well, I mean, I can say from my perspective, I've not seen any change whatsoever. I think, not for publication, private and confidential still is the top of most of these letters. They're still citing a lot of cases. They're still not answering the journalist questions. They're still sending their letters to me and not writing back to the journalist. They're still copying in the editor to try to put some pressure on them.
And characterising the journalist as a fraud.
Yeah,
the typical one. Journalist inverted commas. Yeah. As though you're on the take, you've got a ulterior motive.
Yep.
As opposed to just being some bumbling reporter that we all actually are.
Sorry, you want?
Yeah, I was going to say the same. You hope that the debate plays. I suspect the debate does play on the advice that some solicitors are giving their clients. That they always talk about the Streisand effect and how if you sue over a small allegation or a single tweet, you end up bringing more attention to it. And so a lot of good advice might take that into account. But the overall picture is very much like the same as always.
I think business as usual, with the emphasis on business.
Business as usual. Yeah, I think there's been, more. I keep hearing about new slaps, like one over the Qatari World Cup, migrant allegation, deaths of migrants. So yeah, it's all it's all still going on.
There's the danger of these things backfiring as well, isn't it? If you get known as someone if you get known as a slapper, that has the chilling effect that you wanted to have on other reporters. You're known as being someone who hires Carter Ruck or Shillings at the drop of a hat. Then other reporters pick that up, and on a Friday night, their editors will say, "Just do the other story."
Yeah, I think some people embrace, Boys Schiller is another one. They embrace the reputation of being very aggressive and a difficult law firm to handle, or someone who instructs that kind of law firm.
Yeah.
So.
Thank you, Stephen. Did you want to add anything?
I was just going to say that I certainly had the impression that certain known slappers, for want of a better word, after the Russian invasion into Ukraine, those who then became under sanctions, including the ones that sued Catherine Belton, I think it was even Catherine herself who said it sort of became open season on Abramovich after the sanctions, and there was a lot of writing about him that had never happened before because he was known as such a litigious figure previously, and I think that played a role also in Elliot Higgins' case, and his lawyers representing the oligarch Prigozhin who was suing him withdrew their services after, which may have been a reputational issue for them at a certain point, but certainly there are still cases that are emerging, but it's
True.
And interestingly, on Prigozhin, so he now, can't really sue here because he's sanctioned, but actually he sued us in St. Petersburg recently, and a number of other Western organisations. So as you said, some of them are incorrigible, and they will carry on doing these things somewhere. And actually, the claim against the Guardian has been withdrawn unilaterally. We had no correspondence about it in terms of it happening or about its withdrawal. So you sort of, but this is reflective of the approach that these sort of people take, and that just ties you up. When you've got a threat of a claim in a court, most of us as lawyers find that very difficult to just sit back and ignore in some way, and then you're sucked into a process.
Yeah. I think Marina Hyde wrote a column about it being the first thing you think about in the morning and the last thing you think about at night. And doesn't it tell you something about how chilling and terrifying it is to be sued in the London courts, that you get these threats of lawsuits in St. Petersburg? We know the kind of stuff that can involve. One of the letters I got before Kleptopia was threatening me with arrest in Zimbabwe, where I do go from time to time on criminal defamation charges. And yet it's the London lawsuits that are the really terrifying things that keep you awake.
Yeah.
I feel quite strongly about this. I'm doing a case for an organisation called Realtid at the moment, who are speaking later in the conference. And I've learned a bit about Swedish law during that case. And in Sweden, when you work for a registered media organisation, you as a journalist can't be sued personally. And I do struggle slightly with the concept that journalists like Tom and others in this room or be watching online, for doing their job and engaging in very difficult investigative journalism, they routinely get dragged through the courts, it potentially exposed to personal liability, potentially bankrupted. Is that the sort of society we want to live in? And so, this sort of personal targeting of journalists I find particularly unattractive.
Just one more thing to add to that.
All right, one more, and then I'm going to move on to another question.
But it's quite important as well. It's nice to hear these things, but more important than the journalist lives becoming sort of very hard in those ways is what it does to sources, who are in, generally speaking, at far greater personal risk, and the strain for them of being aware that the phone, laptop, notebooks of the journalists with which they've entrusted life or death secrets are coming under not surveillance, but also through legal means, all this scrutiny. That is really appalling and a far greater ordeal, and one that will never get any recognition than even this admittedly very tough stuff that the journalists themselves have to go through.
Well, and if you're being, surveyed in a car park, what on earth's happening to sources in terms of electronic tracing?
Precisely, yeah. We have to use techniques in London now that I learned to use in Nigeria and Zimbabwe and Kazakhstan, and the difficulty of managing sources safely, which is the first sacred duty, is really hard these days.
Right. Rupert, you mentioned the issue of where you set the bar. And, let me be perhaps a little contrarian here. When is a slap not a slap? If I happen to be an innocent but very wealthy person and I'm prepared to spend as much as it takes to defend my reputation, at what point am I considered to be slapping whoever the other party is, rather than just trying to defend my reputation? We all have a right to do that.
Yeah, it's a sort of $1 million question.
That's why I'm asking an expensive lawyer.
Well, what the model law proposes is looking at hallmarks. I mean, one thing I feel is if you start trying to look at the intention of the claimant in an early interlocutory strikeout application, these reforms will be a dead duck. They'll be completely useless, because the intention will be set out in a witness statement or pleaded, and the judge will just have to, without cross-examination, assume that intention's right, assume the claim is legitimate. It may have only been a tweet that was read 20, 50 times in the jurisdiction, but this oligarch really needs his vindication because it's a very serious allegation. I think Gavin Miller, KC, in a recent article on Prospect magazine, says the starting point should be looking at the value of the speech in question and weighing that against the potential impact on the claimant if their claim wasn't allowed to proceed. The model law proposes indicative factors to try and identify a slap, and once a slap's identified, there's then a merits test that's higher than summary judgment that effectively this case looks like it is likely or very likely to succeed. And even if it's likely to succeed, even if you're Abramovich and you've got a great case on publication, on the allegation, that there needs to be some evaluative exercise where you look at the benefit of allowing this speech to subside and potential impact on somebody who might in reality, for example, being a global holding company, what's really the impact on its reputation? Yeah.
Thank you. I mean, I'm sure that even as we speak, an anti-SLAPP coalition is probably forming out there.
It's formed,
of course, who will fight this, and this is going to be a key challenge I think we have to overcome is the definitional one, which is boring and taxonomic, but it'll be important in law.
But a lot of this never. Sorry,
no, you go first, Tom.
Well, maybe we're going to say the same thing. A lot of this never needs to go anywhere near a court.
Yeah.
If you're a journalist in good faith, this stuff is all done in good faith when it's done well. You are genuinely saying, these are my facts. Are they right? You're doing difficult investigative work. Repub is not a charade. You're saying this is what I think has happened. What's your side? What's your account?
And I was going to say, sorry.
And you can just if you put it and it's wrong, and that can be pointed out to you, you can correct it.
Yeah.
Thank you.
But I was just going to say, I mean, this is the point that would also be helpful. An early dismissal mechanism is reviewing the behaviour not only of the journalist, who's always under the spotlight, but also the behaviour of the claimant and their lawyers in terms of how they've engaged, because so often journalists we speak to talk about the fact that the right to reply has now just become a sort of bad faith process, and you put, as Jill was explaining, you put these facts and they don't come back with anything that you can actually publish, and so I think
farcical. It's farcical often. It will include a line, you see them every day. There are. I feel I should warn you, and it wouldn't be me. It would be you and the editor. I feel I must warn you that your journalist has made some serious factual errors, but it's not our job to point them out.
Yeah, but don't set them out. Exactly. Yeah. There are multiple inaccuracies in what you say, and then there's not a single one actually said. And I think also, as you say, there are also multiple ways in which you can try to get these things remedied before you need to go anywhere near a court. Sledgehammer and nuts come to mind in a lot of these cases, but these are very, very large sledgehammers which are extraordinarily expensive platinum plated sledgehammers to cut because you can go to the journalist, you can go to the publisher, you can go internally to them. The media organizations are all signed up to codes of conduct that are about accuracy. There are sometimes external regulators beyond that. So, there's a multiplicity of places that people can go to where they do not need to go to the courts to get these issues resolved.
I'm going to keep moving us on if I may. Just on that, you touched on the Solicitor's Regulatory Authority, the SRA, earlier, and we've had an anonymous question. Have any of the panelists had experience of making complaints to the SRA, and can you say anything about the experience? And can I broaden that out a little bit more? Because we're not just talking about solicitors or lawyers here. We're talking about PR firms who are very invested in the business of building reputations or protecting them. Can we talk a bit about the specific question we've had, but also broaden it out? Who are the other players and how are they going to be addressed in this model law, for example?
Well, I mean, I'll start, no, I've not made a complaint to the SRA. I've thought about it, but then, the next story comes along and you move on and also you've never felt that there's been anything that you could hang it on. There's not been a peg, whereas now there is a peg. There's a language and a peg. And I think that, as I said, it is something that us in-house lawyers need to look at now. I mean, The Guardian did submit to the government's call for evidence an anonymous set of papers on a confidential basis of some of the exchanges that we had with most of the law firms that we've been talking about as examples of what we deal with. But I'm also aware that we're resourced, we're lawyers. You can take it on the chin much easier.
But so in summary, we need to up our game in getting in touch with the SRA, and they need to up their game in doing something.
Well, we need to see whether the SRA then is willing to put its money where its mouth is, in that sense as well.
Yeah, thank you. And well, let's just move along the line, shall we?
Yeah, I mean, I'll be interested to see the impact of the warning notice. The last memorable warning notice was when the SRA warned against the use of NDAs after the sort of Weinstein and Me Too scandal. Yeah. And I'm not an employment lawyer, but I get the impression that improved practice. I mean, to be fair, clients do occasionally complain to the SRA. I normally historically have advised them it won't go anywhere. But to be fair to the SRA, this is an iceberg issue. This is something that they haven't had much visibility on because of the threats, because people, when you cut the story, you cut the name from the story, or you settle, you then keep quiet. And so they don't have sight of it.
But equally, that excuse is now wearing a bit thin.
That is wearing thin. But it's also the difficulty with both legislation and with the SRA regulating this area is we can't lose sight of what we're trying to build is something that deals with the problem of SLAPPs, but also recognizes important Article 6 rights to representation, the difficulty of, should lawyers, before they put their client's case, warrant, exactly that their instructions are accurate? How far do they go before they write that letter of claim? Or plead that case. And I think in many ways the guidance and the debate and legislation should help guide those who are acting for individuals in thinking carefully about what we need to do before we write this letter of claim. How do we act responsibly?
Thank you. I think Tom's going to pop, or Susan might pop first if they don't get in. So,
well, no. There's a
conferring.
We're not going to talk about because I don't think it's probably. But I think I talk about it in the broadest terms, which is that my understanding of it is to do with a journalist who's been incredibly badly treated on an important story, and the attempts to call the London law firm that acted against this journalist to account at the SRA have been, it's been remarkable how hard it has been to get the SRA to act. I think that's the lesson of my understanding of this case.
I hope they're listening to this.
Yeah.
Well, I'd say that so in researching the London Calling report, which was published earlier this year, I spoke to a lot of journalists and I asked them if they had complained to the SRA. And there are only a handful, I mean, I think maybe two even, that I know did, and they didn't get anywhere. But this was before March, when the SRA for the first time ever wrote about SLAPPs in their updated conduct and dispute guidance. And then in the last few months, they have been quite proactive. They've opened and reopened old cases that had previously not got the attention that they warranted, and possibly because they didn't have the framework in which, Jill was saying, the peg to hang it on. But they have since then announced that they're opening a thematic review into this. They've opened almost 30 cases that potentially are SLAPP related, and they're investigating them. And then now, following up on our recommendation, producing this warning notice on SLAPP, which once it's out there, will hopefully create a much clearer framework by which people can complain, because they've got something to kind of, complain against.
Well, that sounds like it's moving in the right direction, because naming and shaming, I think, is at least the secondary weapon to having a SLAPP law, is simply dragging these law firms through the press, or not through the courts, but through the mud of reputation of their own for being associated with cases that are clearly vexatious. But I've got a gentleman here, you sir, who wanted to ask a question.
Right from Index on Censorship.
Manu bears some of these scars himself.
I bear some of these scars. I won't go into it again because I'll only well up like I did last year at the conference.
And I'll shut you down for not asking a question anyway, so go ahead.
But yes, I'd like the panel to expand on Jill's point, which I think was very well made, about the protections that are given by a large news organisation. Tom has mentioned Marina Hyde's fears of waking up in the morning and being concerned about this. I know Tom bears the scars himself, but Tom and Marina were represented by large organisations with a lot of legal backing. What about freelancers? What about small magazines like Index on Censorship? What about the new landscape of journalism with increasing numbers of journalists being on Substack? How does our campaign help them?
Well, I mean, I mentioned resources and training. I mean, I think, one of the things that the Anti-SLAPP Coalition, the UK one and the wider one, have been trying to do is pull together one list of lawyers, so that if you're sued or being threatened with being sued, there are places you can go to all over Europe where you can get, hopefully, reasonably priced, if not free, legal advice, which is some comfort. I accept that lawyers are not going to be the huggy kissy sort of dealing with your mental health issues, but it's a start at least to have there are some organisations that also offer some financial help. As I said, I think also we need to get in place training, pro bono training, so that lawyers, so that journalists can get their pre-publication processes right, because certainly in the UK, ultimately your Section 4 defence is going to depend on having done the right thing up to a certain level. So, I think that there are those sort of things. There are also a number of whistleblowing charities that can help the sources, that can give them that more holistic help that they need. But that's a slow process. That needs funding. Getting the funding to provide that sort of help is well, I mean, you'll all know that far better than me, that the funding battles that there are to be fought, and it may not be attractive for
Tom. And I'm conscious of time, so let's keep it tight.
Well, I mean, there's obviously the case that's come up now of the Nazarbayev Foundation, which shares its name but is entirely unconnected with a Central Asian corrupt tyrant, and
that's your opinion.
That's a relief.
Pretty well documented. He's gone after the Bureau of Investigative Journalism, hasn't he, and Open Democracy. I think Open Democracy wouldn't mind me saying, I think they've said themselves that this is the kind of case on their kind of budgets for the brilliant work they do that's a big problem. I think there's something, maybe one quick thought, which is something sort of cultural that starts to change. You might call it sort of Hislopification. That I think Ian Hislop's probably the most pursued man in Britain, and he was a private eye. They famously sent that magnificent response that just said, "How would your client respond if we just told him to fuck off?" And there's got to be a tilt in the balance of power here. It's to do with costs, it's to do with this climate, it's to do with the judgments judges give, and the ability of news organisations to say, no, we did some honest, good faith reporting. We're pretty sure we're right. You haven't shown us anything that we're wrong. Fuck off.
I'm going to take another question from the room. There was a gentleman here who had his hand up. Yes, you, sir.
Wanting to go back to the point where very few people had raised the question of reporting law firms to the SRA. It seems to me it would be incredibly helpful to the SRA in terms of understanding the scope and depth and breadth of the problem if people did go back now and pull out their threatening letters, particularly to individual journalists, because essentially they're unrepresented. And I think that that might be a way of demonstrating that there is a regulatory problem and for them to show their sharper and more jagged teeth. What do you think?
So there's a call to action there. Quick replies.
And if anybody wants any sort of advice on that, they're very free to get in touch with me.
And I mean, I think, the NUJ and the News Media Association, which have encompassed the smaller, more regional organisations, could, I think they have been asking, but maybe there again needs to be a sort of concerted effort on their part to get the individual journalists to put these things together and either give them to you or to put them so that there is they get the perspective.
One of the fantastic things about this conference, the conference last year, and this whole debate is people sharing notes. And I completely agree, Mark, that we should be sharing those notes to the extent we can with the regulator. It's only if they see the problem that they can act.
I think that is why there has been action, by the way, because the MOJ's consultation brought forward opportunity for people to submit evidence that also they submitted to the SRA. So I think, the action comes from seeing the evidence of the problem.
Yeah.
And I think, clearly we haven't had the implementation yet. So the more evidence, the better to really push it across the line.
And at the risk of being parochial, do include your MP. I'm going to do my test that I always do. Anybody from the UK in this room, do you know who your MP is? Please raise your hand if you do.
Jeremy Hunt.
Okay. Get him out of here. Okay. Yes. So we know we've got more than I often find, I have to say. Do consider dropping them a line too, because they are the people who are going to either resist or support this legislation. They will get some very well argued cases against this legislation from some of the best legal brains in the country who are making a lot of money. So it is down to you, citizens, to make your MPs sit up and pay attention, to move this up the agenda and get it through. It's got to get through both houses, and we have a lot of legal expertise in the House of Lords, not all of whom may be of the same party as some of us. So pitch over. You, sir.
Just going back to Rupert's point about Article 6, I mean, a lot of people are against, say, for a more robust ID dismissal mechanism because they think it interferes with the right to a fair trial. But I'm more interested in exploring and hearing the panel's thoughts about the risk of SLAPPs for journalists and public watchdogs, for them to access their Article 6 rights. Because as everyone knows, most of this happens before getting to court because they can't afford to get to court. So is anyone's thoughts just on the Article 6 implications of the current SLAPP regime as it impacts public watchdogs? Thank you.
Rupert, do you want to kick off with that?
Well, yeah, our legal system, it's a really good point. Our legal system, which most lawyers are quite proud of, is unlike Europe, a lot of our European neighbours, where they might have an investigating judge who looks into the matter. We've got, it's very adversarial, and it's all cards on the table. It's meant to be, Rolls Royce. You share everything for or against you. And the heart of this SLAPP problem, as everyone keeps noting, is costs. The way our whole legal system is set up, it achieves fairness by assuming everyone's a good actor and that they're going to share their evidence. And that process, when you're dealing with SLAPPs, is ruinously expensive. Apple and Samsung can hammer this stuff out, but Index and censorship can't afford to do that when they're up against autocrats around the world. So this legislation and this warning notice, it's trying to deal with that issue. But the way the whole system's set up It's too expensive. So, and there are, over the last year, I've had quite a lot of informal conversations with solicitors and barristers, silks who are a lot brighter than me, and and some of them are incredibly positive about the need for change, and some say it's just not doable. We've got common law abusive process, but it's not workable. I mean, I'm an optimist, and I think by dealing with the regulatory side, by looking at costs, by putting in a statutory mechanism which will effectively chill abusive claims, all of these things will be playing on the solicitor's mind when they're advising their client, or probably more likely their client's conciliary, and it'll allow more stories to be published, and it will give more space for free speech. But there's no panacea, and that's why we're looking at all these areas.
But you're right, that is going to be a key battleground, I'm sure.
And I think pre-action protocol, the media pre-action protocol, probably could have another look at putting something on SLAPPs in it. But that's another Civil Rules Committee issue.
I'm conscious of time. I'm going to take 2 or 3 questions together, if I may, but I just can't resist one which has said the main issue is finding attorneys who are ready to go up against the offending attorneys, not wanting to find a flood of business cards coming in or promote any particular law firm. There are other brands available, but I think probably if you direct your inquiries to the organisers, they may be able to help you on that. Madam, you've been very patient, and I'll take the gentleman behind you after that.
Okay, I'm Ursula Smart, and I'm a legal academic, and I write media and entertainment law. So I can only work with law as is. So you've mentioned the Article 10, freedom of expression. Where do you think the legislation sits now? I need to know, where is the online, what is now called safety bill? Where is this one? The anti-SLAPP bill, and then of course Dominic Raab is promoting ultimately as probably doing away with the Human Rights Act 1998. I'm looking at section 12 of that. So where is the ranking order? And that's really a question to you, Chair, because you are there. And I just need to know, I'm just publishing the current 5th edition of my book. Here is the advert, but I can only write about a bill in there. And as my students know, a bill is not yet in law. So where are we in the ranking order currently?
There's a long and complicated answer, and my role is to usually pass the blame to other panels. This anti-SLAPP law is just a model at the moment. It isn't anywhere, and this is always my caution. Now, if ever there was a time, unfortunately because of Ukraine, to get this pushed up the list, now is that time. Some really important issues in law wait years for an opportunity like this, and we really have to drive it home, which you all have a role in. Can I just underline that again? You, sir.
Thank you very much. My name is James Nixie. I work for Chatham House, and I also have some scars, which I can't talk about. But so my question is different, and it's to the 2 lawyers, if I may. Maria Ojanakidze, in her intro, she mentioned threatening not for publication letters. And my question is, just because it says not for publication, does that actually mean you can't publish it just because someone's written 3 words on it? Because that strikes me as being potentially important if you want to do something about it, but
just ignore.
I don't know.
That's my legal advice. Ignore it. It's a unilaterally imposed label that has no meaning, no contract, and yeah, that's my advice.
Yeah, I don't even notice it when I see it on letters, because it's on every letter and it's got no real weight.
I think many people do, especially if they're not practiced in receiving these, which is why it's been so successful. It was very hard to even get journalists to talk to me about the letters they received, because they were saying, oh, but it says private and confidential, I can't talk to you about it. And I think there's already been a bit of a shift, because clearly people have talked about cases, and I think that's encouraged others to do so. But the fact that is written on everything, I mean, as you say, you're well versed. I
mean, I've had some ridiculous conversations with claimant lawyers when I've just got fed up with it. I had one that said not for publication, private and confidential, and legally privileged, and you just go, it's rubbish. And on a Friday night, there was then this ding dong between me and them where I kept saying, it's rubbish. Why are you doing this? And you just go, I ended up going enough said at the end of it because I just thought,
slightly politer than yours.
One of the ways of identifying SLAPP, of course, is it arrives at length on a Friday night.
Yeah.
Yes.
Tom, did you want to? Sorry, I thought you were trying to.
No, I just agree with all of that. Yeah.
Right.
Yeah, and I mean, on legislation, you're right. There's still a way to go. These things are all still drafts. There's no. I mean, the attempt to put something into the economic crimes bill got knocked out, didn't it, last week?
Yeah.
So there's a way to go on all these things, and there's some bigger reforms possibly that are needed around the edges, but that's not going to come yet, I don't think.
So when we had the debate on the economic ECB 1, as I call it, the economic crime bill that is now passed, the government did commit to consulting on this. They have consulted on it. You contributed to it, but we just need to keep that momentum going. And an example I was giving someone earlier of a related topic. Today is the first day that I've read the Financial Times and there isn't a story about Ukraine. These things go off the boil, and we really need to seize this opportunity now to get this driven through and keep the pressure up. Right to your MP, right to Dominic Raab. Do it all. I think you had a question.
Hi, Jeanette Smith. So we were talking earlier about the imbalance in the courts, and this might be a naive question, but obviously one of the things that makes UK courts so attractive is the onus is on the journalist in libel cases to actually prove their facts. Is there any appetite to change that, or is that just too much of a leap?
Loads of appetite, too much of a leap. I mean, it comes up every time, but the appetite on the lawmakers and wherever to change that burden of proof. I mean, we've suggested it, for example, on Section 1 on the serious harm, on Section 4, that you could have small bits where there's public interest journalism where you reverse the burden. The government in its response to the SLAPP call for evidence, said we're not going into defamation, basically. We're not going into that wider area. So I think for the time being, that is a not going anywhere.
Thank you. Another question in the room. I thought there was a hand up at the back. Right at the back there, please.
Hi, I'm the legal director of Protect, and we support whistleblowers. So I was cheering on Tom because yes, journalists suffer a lot. But the sources and the workers, whistleblowers, who just think they're doing the right thing by bringing a concern, usually in 99% of cases, internally to the employer first before they're forced to escalate because no one does anything about it. They suffer an awful lot of exactly the same kind of things. And you hear about it even less than you hear about what happens to journalists. And we do, obviously, because they call us. But my problem is that I don't.
And your question, I hope.
And my question is that I don't know how to reconcile the fact that if we talk about it and if we publicize these slaps that our whistleblowers suffer, we give ideas to rogue employers who think, oh, actually, I hadn't thought about that, but maybe I could start a claim for breach of confidential information or whatever to silence my whistleblower. So how do you reconcile that sort of shining a light on these tactics, but obviously not giving new ideas to rogues?
My answer to that would be, I think you have to shine the light anyway, because that's the way you get through the tunnel to the other end. People talk to each other. The clever lawyers will always find ways. I mean, whistleblowing is another area of life which I'm also involved with, and that's a scandal by itself for another time. But I think not talking about it in the hope that people won't pick up on it as a tool, I think is, well, optimistic. And pessimists say things couldn't get any worse. Optimists say, no, they could. So we'll see. Tom, did you want to add something?
Well, I think that it's important that we've been talking about journalism almost the whole time, but obviously this whole thing is framed as attacks on public participation.
Yeah.
And that's crucial because, yes, sources and whistleblowers don't, burdensome and difficult though they are, these kind of public interest defences of journalism aren't available to sources, or if they are, they're in very different and limited ways. And there are cases at the moment, there's the case of Charlotte Leslie, right, former Tory MP, who raised some questions about a major donor, including his connections to Russia, and the donor and his lawyers at Carter Rock have been going after her, and ever since. He would say that he's just trying to vindicate his reputation. She would say that she's raised the alarm and she's suffered for it. But there are these cases that are outside journalism, and I think it's very important that we remember that is part of public participation as well.
Well, and the national security bill that's going through at the moment, it doesn't have any proper public interest protections for journalists or for whistleblowers. So, again, there are, you have to look at these things sometimes with the wider spotlight, because that's across the board. That's public interest, public participation in the debate.
Thank you, Susan.
I was just going to say, and the model law that the UK Anti-SLAPP Coalition has put forward would apply to anyone who felt that they had been subject to a slap. So it's not, pegged on only journalistic protections. And moreover, it would, I think it's already been raised, but just to say again, it would work for any law that was being used, because as we've already heard, it's not just defamation. And I think that's what would be quite neat about having this as a standalone law, is because it wouldn't, it doesn't involve going in and working with pre-existing laws and messing around there. It's something new that comes in on top.
Thank you. I didn't get an answer to my question earlier, so I'm going to put the panel on the spot again. It's not just evil lawyers. What about the reputation management industry? Because they seem to be not touched by this, and yet they are a very powerful aspect. Their own trade body, I see, has a certain amount of grief of its own in the papers today, which, again, for another time. But how do we get at those sort of enablers?
Well, I think you're right. I think there's private intelligence firms.
Yep.
Public relations company. Bell Pottinger might have been the extreme example that suffered the consequences. And I think that I'm not close to the reform there, but there has been some improvement in regulation of PRs. But it is the sort of very wealthy claimant who's got that trinity of aggressive claimant, solicitor, public relations spinner, and private intelligence company. I think that's deeply attractive, unattractive. And I think journalism has a role in covering the non-legal sides of that, in particular. You can subject access request if you think if Tom thinks a private intelligence firm is processing his data, they're actually quite susceptible to. He's allowed to ask to see what data they're processing. So there are potentially legal avenues as well.
There's also a cultural thing here, which is that I remember when I was just starting out, a PR firm was calling me to just feed me some dirt on his client's competitor, and just said, "Look, I know you're just starting, mate, so you're obviously not going to mention us, are you?" I said, "No, of course not. I often think back to that conversation. That is the climate. That in the same way that we never used to mention lawyers, I think that every time some scurrilous oligarch gives some nonsensical response to a story, it should be said, we should say they said through their lawyers' shillings or whoever it may be. In the same way, I think it's quite important to start when you get. Some of the way that the Roman Abramovich's PR operation treated Catherine Belton, from my understanding, it was pretty appalling. If we're saying such and such a person said through their PR firm X, Y, Z, private intelligence agencies is a different conversation we can get onto if you want to, but with PR, I think that would be important, just exposing that they are a massive cog in the machine of the public record.
And also, it's sort of, some of it's nefarious behind the scenes stuff, isn't it? So it's briefing out, briefing under, as well as the sort of the direct correspondence.
Yeah, and black PR, as we say, so the stuff with no fingerprints, setting up the websites, getting the independent academic.
Spinning, going to another newspaper and getting your version of the story out before, because the journalist's written to you and it's coming. So, but how you manage those practices. I don't know.
Well, we've given the SRA quite a beating this morning, and there may be equivalent bodies that we should also be getting after to name and shame.
But it's also just, sorry.
I was going to say your point's such a good one though, because that's how exposing that this is what's happening.
This is to remember. This comes back to what I was saying about my case and how obviously so many of these cases are obviously ludicrous. Like, and you look at the senior employees of some of these major London law firms. They're not lawyers at all. They're ex-military, ex-intelligence, so on.
There's one in particular that we could mention who, when you go on their website, it's quite hard to find the lawyers. Right. It's full of reputation management.
Right, because this is
a PR.
It's in the legal industry.
We have 5 minutes left, so I'm going to cut you, Tom. Okay. But comedy is a very powerful weapon, and I think pointing out the just sheer, absurd case of the week might be one way of getting public attention to this. We've got 5 minutes left, and I've had people from all over the world, which is fascinating actually, Central America, West Africa, South Africa, asking questions. And one thematic one, which is quite general, but I'd see what you say, is if we can do this in the UK, how is this going to be picked up in other countries, other areas? Are we leading the way here? Are we playing catch up? Is there a chance to really break out? Because as Tom has illustrated, most of these cases aren't necessarily UK specific at all.
No, and a lot of the journalists who get targeted by London firms are operating in Malta, Nigeria, wherever it may be, where they've got enough serious difficulties doing their job.
Yeah. So have you detected in your work other countries watching us carefully saying, oh, we could copy this? Or the reverse, perhaps?
I think we're slightly behind the curve on this. Obviously, the States have had, anti-SLAPP legislation. Canada's had it. South Africa, and in terms of environmental activism, public participation in the wider sense, have had it. And the European anti-SLAPP movement is ahead of the game than here, in the sense that they've got a draft directive, and there's been some regulation, and Council of Europe are on it. So to that extent, in Europe, I think we've been following, but as part of a group that is all talking together, and that certainly the anti-SLAPP that we had a year ago, that was just the internal one. We had South Africans talking to us. So I think there is a wider movement. I mean, as for, it's hard enough trying to, as Susan and Charlie will tell you, managing the UK one, let alone the wider European one, let alone a global one. Again, you're going to come back to resources and organisation. But I think there is an awareness. But, and to be positive about something, at least on the whole in the UK, we're not sued by judges or politicians, or rarely. There's one that you've just mentioned that will park, but generally we're not sued.
At Westminster, at least. Yeah.
But whereas, in a lot of these European and other countries, it's the politicians. And, that's a democratic deficit issue that is a bit above my station. But.
Thank you.
I think another way of looking at it is Europe's doing something about it. America has done something about it. Going back to Tom's point about London and the UK being at the epicenter. If we don't do something about this now, we're going to be left behind. We're going to be the problem state, the pariah state that allows lawfare, and that might make the problem even worse. The other thing I'd say is there are many foreign defendants who get letters from London and even get sued from London, and the potential jurisdiction grounds to knock out these cases, but they are expensive to run, and in themselves, when you're served by proceedings in a European or country around the world, and you've got 21 days to instruct an English lawyer and apply to challenge jurisdiction, if it's hard for UK journalists and NGOs to fight libel cases, imagine doing that from a foreign jurisdiction.
Indeed, Tom.
But this is just to go back to the bigger picture of this, what I call a war. The other side of the argument here, and it goes for the City of London money laundering industry as well, that's where you mainly hear it, is you don't hear it put in these terms. Obviously, it's the reputation of this argument is very nicely managed, but essentially says this is a big UK industry. This is big, and this is global post-Brexit Britain. And thank you very much. We will put out the calling card and say, slappers of the world, what have you? And that is the other side of this argument. That's the context of it.
Thank you. We are at time, and I've got to run away in a minute. But Susan, I'm going to give you a chance to gather your thoughts, to give us some last words, if you like. I just have one more question to other members of the panel. A lot of the responsibility for deciding is it a slap, isn't it a slap, is going to rest on the shoulders of the judiciary. Are they awake? Are they up to the task? Is it too big a burden to bear? Jill, I can see you smiling.
Well, as I said, I think Matthew Nicklin has given some indications that he is aware of the issue. But I think that training of judges on free speech issues generally is pretty poor. They're pretty poor on open justice. They're not aware of the bigger issues. So again, transparency, publicity is the best thing we can do in that way.
Thank you.
I agree with Jill. Our specialist media judges understand the issues, but the wider judiciary, there is a process, an education process. They might have spent their whole career in criminal law or something else, and so. But I do think we've got an outstanding judiciary. They just need to be given the right tools to deal with this problem.
Thank you. Well, let's hope they are. Tom, last word from you.
The Nicklin judgment in my case is fantastic, and the way that I thought he really encapsulated a lot of these arguments absolutely brilliantly. But what's always happened with the rich and powerful is that they found one tool that was defamation for a long time, and then they suddenly thought GDPR or data confidentiality, privacy, and then you can get into judges who are not so familiar with these kind of tactics and wouldn't be so alive to the dangers of them being abused.
Really good point. Thank you. Susan, last chance, last words for us?
Well, I was just going to say, thus far the UK has been behind the curve, but there is really an opportunity. I mean, and I think it's important for the UK's reputation as well. The US already doesn't recognise libel judgments in the UK. The EU directive, which we'll hear more about in a later session, we are considered a third party and will not be recognised either. And at the moment, there isn't a national anti-SLAPP law, so the UK still has the opportunity to be the first to introduce that. So I think it could embrace it, and it's something that it could really lead the way on. Just needs to do it. So.
Thank you very much. And on that note, just do it. Remember, you may be online, you may be sitting in the audience, but you're all part of this. And please do, bad things happen because good people do nothing. So do lots, please. I'd like to just wrap up now by asking you to join with me in thanking the members of our panel who, for I think you'll agree, a fascinating and insightful session. Thank you very much.